We're going to get started. It's Saturday. It's the last day. We're almost there, and this is a great panel. We're not going to have enough time for them, so this will be very brief. I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project. This is our third time having this conversation with different just people within the Federalist Society, within the conservative legal movement, who are finding different paths that align with their priorities and are consistent with sort of how they understand their mission within the conservative legal movement. Today's program is focusing specifically on the path to impact litigation. I'm delighted to have Kate Todd moderating this panel again. She is the managing partner in the DC office of Ellis, Cipollone, and she has had an amazing career path to get her to this point in government service, private practice, nonprofit world, and who better? So Kate, the floor is yours.
Thank you, Alita, and I also want to thank the Federalist Society for continuing to sponsor, as Alita mentioned. I think this is the third year we're doing this program, and rightly, much of this convention focuses on what the law is, what the law should be, interpretation, but I think it's sort of irresistible when you have the breadth of experience here, and people in law school, people are law clerks, second-year associates, all in one place. It's irresistible not to go ahead and put together a panel to talk about how to do law, the work of law, the practice of law. Now, Alita didn't mention that she probably wouldn't, and she's going to cringe a little bit, that she and I have gotten some consistent negative feedback about doing this program. And I think it's coming from the younger set, and it goes something like this. It's great. I really enjoyed the speakers. They never talk about the moderator, but the speakers. But the speakers were highly skilled and highly accomplished and really successful, and I'm having a little difficulty relating.
So that's why they invited me.
No. So, I mean, first I will say it's work different, not work mediocre. So, I don't really think that would be a big draw for people, but it's also, I will apologize that once again we have highly accomplished, highly successful, skilled lawyers. But what I do ask the speakers to do, because we are talking about the work of law, is to maybe not go full elevator pitch, business pitch to your clients, but add where you're comfortable some of the challenges and some of the hiccups and maybe occasionally a mistake and some of the just hard part of what you do, because none of us puts that in our bios. It's not really interesting. And speaking of bios, you have their bios. I'm not going to recount them. I kind of want to just dive into the conversation. So Heather, I would love to start with you. You're based in Texas. You were an assistant SG in the Texas AG's office. And now you're on a very small platform, a boutique, doing cutting-edge litigation on things you care about. So tell us about your platform, why a boutique, and what's great about it, and maybe what's not so great about it.
Sure. Well, thank you very much, first of all, for having me, Federalist Society, and for Alita organizing this panel, and to Kate as well. So I followed, I guess, a somewhat unconventional path after law school. The only job I applied for was at a nonprofit, ADF, and I worked there for about 10 years. Some of those years were part-time after I had my first baby, and took a significant part of another year off after my third child was born. And then we moved to Texas and started working at the Texas AG's office. My husband worked there as well, and as Kate mentioned, I was in the SG's office, mainly doing appeals. So why did I leave the AG's office, and why did I start a boutique law firm? It seemed to me that there was greater opportunity for the skills that I had learned along the way to sort of be untethered to just one client, essentially, the state of Texas. And it also seemed that there's a need for, in various contexts with various different types of clients, essentially a conservative firm that is skilled and talented and can provide legal services at a good value as compared to maybe some of the bigger firms, but still had the level of skill there that could get things done. And in a lot of contexts, certain clients don't necessarily want the big firms, especially with some of the social activism they've been engaging in, to represent them. Sometimes it looks better, especially for government clients, to not have a interest organization representing them. It's better to just have a firm. So we saw that as an opportunity to kind of get in and broaden our practice a little bit and use our skills to sort of coordinate broader litigation strategies to further the conservative movement across a variety of different contexts. So,
yeah, do you want to just share some of your greatest hits or some of the projects you're working on? And
sure. So, of course, when we did this, we had no clue whether it was going to work. We're about 3 years out. We started the firm in October of 2020, which was the worst time possible to start a new business. And I would say that we had very challenging circumstances because coming from a government job, my law partner also worked at the Texas AG's office. And so coming from government service, we didn't have any clients to bring with us. We didn't have a book of business necessarily. So it was quite a plunge to move from public service to private practice. So we weren't quite sure if it was going to work, but we thought we had some clients lined up that would hire us, and so we went ahead and took the plunge. And so, one of the hard things to think about leaving the AG's office was I was so spoiled as an ASG there. I got to work on really fun cases. It was a great job, super fun, and I wasn't sure if I would be able to continue doing that kind of work in private practice, but thankfully, we have been able to do that, and it's in large part because of the previous experience that we had. So one of the first jobs that we got right when we left was we represented the Smith County clerk in the Texas Heartbeat Act litigation that went very quickly up to the Supreme Court and back. That was a great opportunity, and it ended up that the clerk, she was named as a defendant class representative, and so the clerk class ended up being a significant part of that case and whether they could be sued in that context. So that was really fun, a lot of work. We've also been able to represent the class of 4,000 Navy service members who had sincere religious objections to the COVID vaccine mandate, and we were able to secure injunctive relief that prevented the Navy from kicking them out, which was extremely gratifying personally for me. But one of the reasons, and so both of those two cases, I would say that the idea for the firm sort of proved to be a good one because we got the job for Smith County because they didn't want the Attorney General's office to represent them, but they knew we knew how to do the job because we had just left the Attorney General's office. And then the Navy, that was a First Liberty case, and First Liberty tenant, my husband works at First Liberty also, but so I had a little bit of an inside connection there, but the First Liberty typically works with firms and other lawyers at big firms typically to do their cases, but because this was COVID, none of those firms would touch this case, and so that presented a great opportunity for us to get in there and represent these very worthy clients. So that's just some of the things we've done.
Thanks. And so James, you obviously you're based inside the Beltway. You just left Big Law, relative what, couple months?
July, yeah.
July. And James had experience in the Trump administration, in the White House, DOJ, and now you've hung your own shingle and are leading a litigation finance fund. So tell us about your platform and any challenges
Sure.
that are happening in that and what you're doing.
Yeah, so first, just to do the sort of how I got where I am. My path is actually pretty boring and conventional. I went to a big law firm and I wanted to do appellate law because doc review looked boring. And that's basically what I did. And then I got to work at the Trump administration, which was really cool. The biggest regret, though, I think, is that I understand why, as a second or third year associate, I thought appellate law would be more interesting. It was pretty interesting. I really wish I had done more trial-oriented stuff. because I am now at a point where it's like I'm pretty old. It's a little late to be doing my first deposition. Maybe Heather will let me ride shotgun someday. But I really wish I knew I had more direct experience doing practical things. And I just think for the young folks in the room, like, yeah, doc review's probably pretty boring. I never did it. But the people who do that actually know what's going on in the case and then are relevant and then get to do the deposition stuff. And that's actually how you destroy your enemies, is through the factual record and through discovery, right? The appellate lawyers can only do so much. It's really the evidentiary stuff that matters. So anyway, so what am I doing now? So I left Jones Day in July. I have a litigation finance fund that is attempting to basically blend lit finance, right? So Burford Capital is the biggest, with impact litigation. So conservative impact suits, and then also supporting, if we can, conservative law firms that are doing kind of a wide range of things that are aligned with the mission. I mean, one of my theories, we'll see, is that big law is becoming an increasingly impossible place for conservative lawyers to practice. And it is certainly becoming an impossible place to do important conservative pro bono and low bono work, which is to say, things where you're not getting paid, whatever, $1,500 an hour to do it. So like a good like Heather's Navy service members case, right? They'll get fees at the end, it sounds like, because they're kicking ass, which is great. But like a big law firm's not going to do that case, right? And there's just not enough. Hopefully it's not Hamas. It's not. There's just not enough. There's not enough lawyers on our side doing this. It's like there's like 100 people, okay, basically, at small law firms fighting the entire AmLaw 100 on all kinds of issues. And so a great example of this would be in Tennessee, they passed a law banning the mutilation of children. And it got, the ACLU and like everybody came in to challenge it. Judge Sutton, when he is good, he is really good, wrote a really nice opinion upholding the law. And one of the points he makes is, these folks say they're, like an oppressed minority, but the entire, all of big law is here supporting them against, basically like Consoy McCarthy, Adam Mortar, and like a couple guys from the AG's office. I mean, it's like you could fill an RV with the amount of lawyers we have willing to defend these things when, public opinion and just morality is obviously on our side. That's a kind of a digression. So the point is, what we would like to be able to do is help people who want to blend that kind of work with profitable, contingent fee plaintiff side cases. So suing woke companies for bad behavior, suing anybody who's really done wrong in a case that has damages, right? Our theory is that you can use that kind of as like a arsenal of democracy to cross-subsidize the important conservative work. And by the way, some of that work is itself important conservative work. So imagine Students for Fair Admissions, but instead of seeking an injunction, you're seeking $1 billion of damages on behalf of everybody who's been discriminated against. And our theory is that we can, by supporting this sort of stuff, we can actually expand the conservative legal ecosystem and hopefully have lots of positive systemic effects across the board on all kinds of issues.
And I want to talk to you both. I mean, you mentioned the appellate piece, which I think is interesting, James, and Heather, I know you have an extensive appellate background. There is a big leap between something that really annoys you, bothers you, a grievance, and actually filing a lawsuit that can win. Can you talk a little bit about what some of the challenges are on getting this impact litigation off the ground? Like, how do you take it from headline of really bad thing into a courtroom and get results?
So I would say for me, I have a little bit of a different background as most appellate lawyers, because I did do a significant amount of trial work before I went to the Texas SG's office. And for all of you younger lawyers in the room, I would encourage you, even if you are interested in appellate work, ultimately to get trial experience as well, because very few appellate lawyers have that experience, and I think it makes you a better lawyer. You're more well-rounded. I think you're better able to understand the demands that the trial lawyers go through, and so you can kind of sit in your ivory tower in your appellate practice and look down on all of the errors that were not preserved because of trial counsel. And when you've actually done that, you kind of understand what the potential pitfalls are. So even if you're sitting in an appellate context and sort of reviewing the trial team's work, I think it helps to be able to pick things out, and I think it also just helps you to be a more well-rounded lawyer. And then, because I've done that, I've worked on cases from like the very beginning, like the grievance stage, like you mentioned, Kate, all the way through appeal, basically to the Supreme Court. One of the best things I did, I think, is when I started my career at ADF, that's essentially what they gave me, is they said, here's this student from Arizona State University who called us and they've got this problem with the university and this event they want to have, like, go for it. And so I worked it up from that stage all the way, through filing the complaint, went through like 25 drafts of the complaint because I didn't know what I was doing. I had a mentor that was kind enough to work through that with me and sort of teach me what to do, and that was just learning on the job. I mean, I went all the way through, I argued the appeal, and so I think that was a very valuable experience. So, as you're looking for opportunities, look for a place that will foster that and will really teach you how to be a lawyer from soup to nuts, in the litigation process. But I think another thing that my time at the nonprofit, another way that it was valuable is that, we worked a lot with the clients and, their personal issues. And so client relations are really, really important. And I think that when you're working with an individual, especially an individual who is standing up for something they believe is important, or who's putting their professional or personal reputation on the line in filing these lawsuits, that has a very different flavor from, say, working with a big corporate client at a big law firm. The values are different. There's a lot that you have to do as a lawyer that is perhaps not something that you read, you learn in law school, but there's a lot of that interpersonal element. And, as lawyers, we are counselors, and sometimes that becomes less legal and more sort of support oriented. And so that's very important, I think, in some of these cases where, for example, in the Navy SEALs case, those guys put a lot on the line to challenge the mandate the way that they did. And, there was a lot of, work with them individually to support that brave stand that they did that I think that work helped prepare me for.
James, what about from your perspective? I'm sure you have sort of a laundry list of issues that you'd like to tackle and potential targets that you would like to hit, but there are quite a few steps between that and getting into the courtroom. Sort of how are you thinking about that and tackling that?
Yeah, I mean, unfortunately, it's a target-rich environment. So the first few months has mostly been me trying to get out and just kind of meet as many people as possible, make sure people know that I exist. I have a lot of friends that are at big law firms. They are not mostly going to be partners for these projects, both because they just don't do plaintiffs' work and because their law firms are not going to want to do things that are really, really edgy and aggressive. Fortunately, I think there's a good number of lawyers out there that are able to do these things. And so then the second piece is taking ideas. We get a lot of incoming. And if you have ideas, come find me after. I'll give you my email, and I love ideas. And most of my job right now is going through 20 ideas and figuring out like which 3 are worth digging into more and which one is actually a real lawsuit that we can put together. So from an idea, then you have to go and you have to try to find lawyers and then plaintiffs and all of that. It's like, this is what plaintiffs lawyers do. It's not that different really from, as best I can tell, from what I used to do at Jones Day, which is go after the federal government for its various misdeeds. Except here you have an even wider playing field because you can basically look at everything that's happening and say, God, that really makes me upset. Okay, is there a legal claim that we can attach to that? So here's an example that just came up. So the recent horrific events in Israel, right, obviously are awful. And so it turns out there are statutes, and you're not allowed to, give money to terrorist organizations to kill people. And so one of the things that I've been thinking about a lot is there a way to bring claims against either American entities or foreign entities that played some role in financing the recent horrific attacks. That's a fairly obvious example. I doubt I'm, the only person thinking about it. But it's interesting. I mean, back at Jones Day, it was like, well, I got to bill my 7.5 hours today, and, it's going to be this and that and whatever. And on the plaintiff side or at the small firm side, you have a lot more latitude to sort of run down the stuff that you're interested in. And if you think there's something there, you can literally make a federal case out of it. And I just think that's, I've really enjoyed it so far, and it seems great.
Well, I want to touch on something you just said, James, about kind of the dynamic in a smaller firm and having some more freedom, and you do, but you also have some more pressures, and there's a little bit less spreading of some of the risk or the need to get some dollars in the door. So let's just talk about the business side of this for a minute, because I think it's cliche, but many people go to law school because they're not going into business and they're risk averse, and now we're talking about some pretty significant risk taking. If there is a product for a law firm in the box, I have not found it, and I would like to know where it exists. How do you, what thoughts or advice would you offer to people that are thinking about a different platform of the sort of business side things they need to think about, either mechanical, mundane, or I'll put a bigger question on the table too, and you can speak to any of it, which is, is doing conservative impact litigation an all or nothing thing? Is it, once you're doing that, you really can't bring other types of clients and traditional defense side corporate work in? Like, how do you sort of think about that blend of work that a boutique might have, whether that's in what you've experienced, Heather or James? I'm assuming you're talking to people that are thinking about leaving big law too, and kind of you're going to be in a role over the next several years, really, of helping shape what direction people take in this. So happy to hear your thoughts on any of the above.
That is a valid concern, and think that's something that I've questioned a lot, just in terms of, are we pigeonholing ourselves too much? Are we going to be able to get enough business from folks who don't mind the, ideological cases that we've taken on? And so far, so good. So it's been okay. We kind of have, some different types of clients. We have individuals, we've got nonprofits, and government clients. And so far, that hasn't been an issue. I'd say probably about 75% to 80% of our docket is impact litigation. And then we have some other things that are, sort of pay the bills. We're in Texas, and there's a saying that, if you are a lawyer in Texas, you're going to be doing some oil and gas work. So we do have a little bit of oil and gas work that we do. But so far it hasn't been an issue, and perhaps that depends on where you are geographically, but our other clients have not seemed to care about the other things that we do. And in fact, I think in some ways that has been a reason why some people hire us, even though that may not necessarily have anything to do with their case. So,
James, do you have thoughts on this?
Yeah, so I now have talked to a lot of smaller firms, so I have some sense of the business model. And I actually, before this happened, I had thought I would probably go do what Heather's done and what others have done after a few years at Jones. I love Jones Day; it's a great firm, but just the autonomy. So I've thought about this a little bit. So my sense is, first, that among the corporate gazelles, some have figured out that people like us are hunting for them, and have realized that hiring somebody who thinks like a conservative might be a good idea, because that could probably help keep them out of trouble. And so I would not be surprised if every little conservative boutique has one or two very savvy corporate clients who has said, maybe I'll just pay these guys like $20,000 a month to tell me if I'm doing something that's going to get me blown up on the launch pad. So I think Heather sort of alluded to this. I think there is actually a market benefit to being a conservative boutique, because the smarter in-house lawyers will say, I want that person to come here and help me. And that can be a nice sort of, kind of guaranteed or pseudo-guaranteed income stream that kind of keeps the lights on while you're doing other stuff. So that's one. Two, there is a lot of money out there for just pure, not like huge money, but enough money for small firms for just pure movement litigation. doing things like ADF cases, First Liberty cases, things like that. You can have a nice docket of that. You're not going to be billing $2,000 an hour, but you also don't need $2,000 an hour to have an enriching life. And then the last piece, and this is where the real money is, the airplane money, is the contingent fee stuff. And I think for that, that's where I can, we now exist. One thing that we exist to do, if you have a docket or portfolio of contingent fee cases that are good cases that are likely to succeed, is we can help you monetize that earlier, right? And we can smooth it out. So, my sense is the traditional plaintiff's lawyer path was like, I go start the plaintiff's firm, I have 10 contingent fee cases, I eat ramen noodles for 6 years, I win my contingent fee cases, and then I'm eating better noodles on a private jet. Maybe we can make it like a smoother path from the beginning to the jet, so that it's not quite so dramatic. And that's something that litigation finance can help with. And that's something that we want to do if the lawyers are aligned with our mission, or the cases are, or ideally both.
And this conversation, and there was a conversation earlier this week in a symposium, is not one that we would have been having 10 years ago at the Federalist Society, or even 5 years ago. And I know from my old hat at the chamber, you start talking about money damages suits and litigation financing, and you get a lot of negative reaction within the conservative legal community. And I'm just wondering, and yet there have been some phenomenal victories that everyone agrees are really great things to have done, right? And do you find that you're still sort of dealing with that stigma or that reticence of like conservative lawyers don't sue? And I don't know, James, if you're sort of tackling this quite a bit, or is everybody just hot and mad and ready to go?
My good friends and former clients at the Chamber Litigation Center are probably not aligned with my new profession, although they've been very nice about it, actually. Look, I mean, corporate America is not our friend. Okay, and when I first became a lawyer, it wasn't that long ago, but 15 years ago or whatever, I think it was different. When I started at Jones Day, I felt like I was representing good companies that were going to make good products that good price, and that was good for the country, and this is what made this country great, and government's the problem, and all that. And something changed. I don't know when. I don't quite know why. It's kind of complicated why, but for whatever reason, these companies have basically, many of them have decided that they are going to be acting like little governments, and they're going to impose all of their social preferences and policies on us. There's been a lot of discussion about this in the last few days. COVID was a real eye-opener, I think, for a lot of people, because you had 3 or 4 tech companies decide that they were going to dictate not only government policy, but what information people are allowed to even obtain about a scientific calamity, even from people who are, well-regarded epidemiologists, not just, some jabroni on Twitter. And so, I forgot what the question was. Sorry, I got so excited.
Defending the conservative viewpoint of going for money. Is it okay to get money as a conservative?
Yeah. First of all, getting money is a good thing. Getting money for conservatives is a really good thing, because that can have all sorts of cross-pollinating effects. Third, I think most conservative lawyers that I talk to either openly support what we're trying to do here, or would admit to you, after a martini, that this is obviously something that has to happen, because the system is totally out of control. And it's crazy to me that we ceded the plaintiff's bar to the left. I mean, why would we do that? First of all, it creates horrible incentives, because the companies are only worried about upsetting the lefties, which of course means they're going to totally hose us, because they think the conservatives aren't going to do anything about it. And two, it's just an enormous, the legal market is like a $600 billion annual industry. Okay, well, like half of that is on the plaintiff side. And so we should go take some of that pie for ourselves and use it to do things that are good for the country.
Heather, do you have any thoughts on this?
I guess on the more practical side, the contingent fee work or the airplane work, as James mentioned, as a small firm, obviously, we didn't really feel like we had the luxury to eat ramen noodles for 6 years, because we both have families and kids and all of that. And so for us, practically speaking, we kind of have a balance. And so we have some, hourly work that pays the bills and keeps us going. And then we have some contingent fee work that we think has the potential to have a broad impact. And so, while that is very risky, we felt like it was worth the risk to take on, but we wouldn't have had the flexibility to do that if we didn't have the sort of the steady work. And so I think that that's part of the thing that you have to think about is the balance of the types of cases that you're taking on. And, the hope, right, is that like James said, that you take one of these contingent fee cases and you hit pay dirt, and then you can fund your activities from there on out. And, hopefully one of those cases that we have will work out that way for us, and we'll be able to have a lot more flexibility, maybe expand our team later, and have a broader reach, and perhaps not have to be as dependent on the safe work, and be able to try to take more risks, because and not stupid risks, but potentially beneficial risks that will either create favorable precedent, either in the courts or in a more informal sense, like James mentioned, with rebalancing the incentives for some of these very powerful cultural actors, corporations and things, so that they realize that there is not just one side to appease, but that there are other folks here in this country who have different views, and basically stay in your lane. So,
yeah, one of the things that was slightly surprising to me on going into a smaller platform, I feel like at a bigger law firm, you're trying to be the only law firm involved, and you're competing with other big law firms. In a smaller platform, there are a lot of things you can't do, right? Or expertise that you don't have. And I think people and I'm curious sort of what your experience is and what you think the needs are for being more organized or having more conversations among the people practicing in this area, because I think while you spend a lot of time in big law going from corporate client to corporate client trying to get more business, in the smaller platform you need to spend a lot of time just talking to other lawyers in the space and figuring out who you want to work with. And so I don't know if either of you want to speak to that, or James, if you're sort of thinking about ways to have multiple boutiques working on something, or kind of, is there a need to be more organized on the conservative plaintiff side?
I mean, I had not thought of that until you just said it, but that's a great idea. I mean, the sort of true plaintiffs bar, like mass tort, pelvic mesh, like real plaintiffs lawyers have tons of this stuff. Conferences, they're always like in Las Vegas, I mean, it's a whole thing.
They don't litigate alone. Like, if you look at the cases, they're
No,
not. It's almost, I mean, it's not just because they're all there for the money piece. Like, they can't all do each of it.
No,
right?
Right. So and they all, it is very organized, and so there is a lot of coordination. And so I think it's good to be part of that. But I had not thought of there's a lot to be said for having more coordination among conservative boutiques that sort of understand, that are all kind of broadly aligned on what we're trying to do here. And that sounds like something I should try to organize. So I'm going to work on that.
Yeah, I think that that's a really great point. I mean, I'd say up until now, we've worked with, in those couple big cases that I mentioned earlier, we were working alongside the Texas Attorney General's office in the Texas Heartbeat Act case, and our Navy SEALs case, we were working alongside First Liberty, so that sort of expanded our capabilities there, because it is just me and my partner at our firm. We have a couple of great contract attorneys that help us out, but we have one case right now where it's essentially us versus about 30 big firm lawyers, and we've been working a lot. So, recognizing, I think, your own human limitations, like you have to be able to, get more resources with others. And I think if there's more coordination with like-minded folks, we are outnumbered, but we don't have to be so outnumbered, right? We don't have to be David versus Goliath. We can be, a few Davids versus Goliath, and that's better than just one. So I think that's a great idea, and there are so many great boutiques out there that are doing great work, and are lawyers that I greatly respect, and I would welcome the opportunity to join forces with any of them. I think that's a great idea. I think we do need to coordinate more, and strategize how to use our more limited resources in a way that's going to have the bigger impact.
And last question, I want people to be thinking of questions because I really do want to turn this over to the audience and have it be interactive. James, my experience in talking about litigation financing is that there are a whole lot of people that don't actually understand what it is. And I don't know how much you feel like you're trying to explain it to people and how it works. And you did talk about this sort of at a high level. Are there resources? Is there somewhere to go? Like if someone really wants to, or just emailing you, like really wants to understand all the different options, and because I think places like the Chamber and others that have taken a particular view of it have described it as something that is, you wouldn't necessarily understand that a lot of corporate America uses litigation financing in its own way, right?
So, I mean, in a nutshell, all the Chamber arguments against it are total bad faith, made up arguments that are just ways to, all they're saying is, we want less litigation against big companies. Well, like, no kidding. So there's a shocker. In terms of learning more about it, so Burford Capital is the biggest fund, and they have a lot of stuff on their website that explains what it is. There's also a group called ILFA, the International Legal Finance Association. They have some stuff on their website. You're also welcome to email me. My email is Burnham, Burnham. This is the hard part. It's named after a river in Colorado. At Vallecito Capital, Vallecito.
I'm glad I didn't try to pronounce it.
And if Vallecito, it's all good. You know, gringo pronunciation is fine. Anyway, so you can email me, and I'm happy to talk to you about it. In like a very condensed version, what it is, it's basically a non-recourse lending product. So that means it's a loan, but you don't put up your house or your office or whatever. The collateral for the loan is your fee interest if it's with a law firm in a particular litigation. Okay, and so it can be either a single case thing where it's like you have a 30% contingent fee if you win this case, and then you'll basically take money from us now, and then we get some of that on the back end if the case succeeds. And if it goes belly up, you keep the money, we lose the money, and it's good. The lawyer gets certainty. Or you could have a lot of cases in the same structure, but the collateral base is broader, so our return would be a little lower. That's the lawyer side. On the client side, which is where corporate America uses it a lot, let's say that like Boeing has a claim against Airbus for $100 million. Boeing doesn't want to pay Kirkland $20 million to bring the case, but it's a $100 million case, so it's worth bringing. They would go to a Burford Capital. This is not really what I do because there's no mission component, but they would go to a Burford Capital and say, give us $20 million, and if we win, you can have $60 million, and we'll pocket the 40, cost-free for Boeing. Kirkland gets their 20, so they're very happy, billing many, many hours to get their $20 million, and Burford gets the $40 million upside. So that's basically what it is. Very, very well established now, and yeah, so.
Okay. I'm going to open it up now to questions from the audience. Yeah? Oh, yeah, Alita's in charge of this part.
Changing the focus slightly, I have a friend, and this is a real friend, not me, who's experienced in tax and administrative law, doesn't need much of a salary, and would love to work in some of this right of center pro bono, but he has no idea how to approach the market. Any thoughts, Turner, about where you would start with that? Is there any central point or anything?
I mean, I would reach out to ADF and First Liberty and all the good, well-known conservative public interest places. My sense is, and y'all would know better than me, but y'all have more people who need help than lawyers who can help. And so if there are folks out there that are willing to help, I would think those are the places to go because they have so much incoming. I don't know, what do you think?
Yeah, I would agree with that. I think that another way to sort of put yourself out there is, hey, I'm willing to help out with this, is getting involved in your local FedSoc chapter, Christian Legal Society, because then you'll hear from other lawyers like, hey, I've got this friend who needs this help or whatever. But yes, I think that reaching out to the nonprofits, ADF, First Liberty, IJ, they rely a lot on pro bono attorneys helping out. I think that would be a great way to sort of jump into that area.
Would you say start as pro bono and then work into a salary
I mean, those organizations do hire salaried lawyers to, do their cases. So if that friend was looking to make a total transition, then that would be a good place to look for a job.
A lot of times, a lot of these are fee shifting statutes too, though. So if you have, you have some successful representations, you will get fees on the back end. And so I know there are plenty of lawyers that make, a good living basically doing fee shifting cases almost exclusively.
Next question.
Before my question, just a quick question for James. You mentioned an interest in possibly doing something against people who fund terror or who give money to terror organizations.
Yeah.
Are you aware of an organization in Israel called Shurat Hadin, the Israel Law Center?
No, but
they do exactly that for the last couple of decades, and they
Yeah.
do it worldwide, and usually they work through local law firms in other countries. They often get information from Mossad where they're promising targets, and then they pursue these organizations and their donors and try to tie up their funds or to get their funds from them and enforce judgments. So they might be interested in working
Yeah.
with you if you contact them.
Yeah.
My question is to do, when you have individual plaintiffs in conservative free market causes, how do you handle the public relations aspect of it? Most of those individuals are probably not very PR savvy. And do you handle that in-house? Do you outsource that to third parties to advise them? Because some of those cases are tried as much outside the courtroom as inside the courtroom as far as the ultimate impact goes.
That's a really great question, and to be honest, I don't think we have a super great answer for it. The way things have gone for us the last couple of years, we've just been so busy that we haven't had the opportunity to really think about that aspect of it, and so we just typically don't comment on pending litigation just to be safe. I think that there are probably places where you could outsource that would be beneficial, and frankly, we just haven't had the financial resources to do that. So, but I think it depends on the case. I think there are some cases that it benefits you to sort of fly under the radar a little bit, at least for a while. And then there are other cases, like you mentioned, that the public perception tends to be very important. So, I guess the one exception to that is the Navy SEALs case that we did with First Liberty. Obviously, First Liberty handled the PR aspects of that very, very well. And so we didn't really have to worry about that. But I think that is a great example of a case that I think the public perception of it was incredibly important. That's a good question, and I'm still sort of exploring the answer to it.
Thank you.
Well, just on that point, though, one of the things that we are trying to develop, and another one of our theories, we'll see if we can deliver, is that in a private equity model, when a private equity fund invests in your startup, they don't just give you money; they give you all kinds of things, support, business connections, advice, CFO functions. That we are going to try to replicate that suite of things. So it's not like we're just the monopoly man and here's your money and see you in 5 years and I hope it works out. And PR is one area where I'd like to think that we can be helpful. I don't have that many practical skills, but one thing I learned a little about in the administration is sort of how the press stuff works. And so we would like to, once we're invested in cases or law firms, be a resource on sort of making sure the public perception side of it is handled so that the lawyers can focus on doing their job, which is winning the case, and we can focus on making sure they're not just getting totally annihilated in the press in a way that's going to prejudice the outcome.
Yeah, and I'll just add on to that. I think maybe I've dealt with this more in the crisis management space, which a lot of crises to manage in recent years. And there are some really great people who are either independent or in small groups on the PR side that can do great work on sort of movement issues and movement litigation, and not everyone in the PR space is good at talking about litigation or sort of understands how to deal with that component. So it's really important that you have somebody who does understand legal, but there are some resources out there, and it sounds like James and I should talk about who some of those people are. But I do think it's critical that if you're filing big things and it's going to be all-out war, that lawyers who, again, typically aren't business people, often are not great PR people. If they're not really good at doing it and comfortable with it, like find the people that are. And I think there's a lot, at least that I know of around here, who've dealt with some pretty hard things. Next question.
Hi, I was hoping that the panel could address the topic that Kate mentioned at the top, which is for the young lawyers and law students in the room, where do you suggest, if we're interested in this, where do we begin? Do we begin at the Jones Days of the world and gather up a book of experience and then move into this space, or do you recommend folks that are excited about this jump right in?
I think that I guess the first point I would make is don't feel locked into a particular path if that doesn't work for you. So if you don't really feel called to go to the big firm path, then don't worry about it. Do what makes sense to you, and I think you'll get there regardless. If you want to work at the big firm, go for it and use that experience to your benefit. I think that the key thing for me is if you would like to get into this type of work, boutiques, we don't have, it's not a very top-down situation, so like I can't hand off work to an associate and just have them do it. You have to be able to do everything, and so you really need that practical experience, not only so that you know what you're doing, but also so that you have the confidence to do what you need to do, and that comes from experience. So my advice is to go somewhere where somebody will give you the opportunity like I had, where they will give you a case that lets you work, you work it up from the ground up, that will let you take depositions, that will let you argue motions, that will let you argue appeals, so that you can get that experience under your belt. And one thing that I wish that I would have known about, or somebody would have told me when I was first leaving law school, is that a great place to get really good experience and also really good connections with good people who can help you do this type of work in the future is to work for a state AG's office. That's not as much money as at a big firm, but you get really good practical experience. A lot of state AG offices, especially the bigger ones in bigger states, there are a lot of great cases, and just the resources, like you will have to work on your own cases, like they've got to spread the wealth, and so that's a really great place to get experience, particularly trial experience, because at a bigger firm, a lot of big firm lawyers don't try cases. Most cases settle before trial, and when you work for the state, you've got a lot of trial work that's available. So that is a really great place to get experience. So that would be my advice.
Yeah, all I would add, I was making fun of big law a little bit, but like most of the best lawyers in the country do work at the large law firms, and there's nothing wrong at all with going to a big law firm for a few years. You will see law practiced at the highest level of professionalism, and you can learn a lot from that. So it's totally great. Jones Day is a great firm. I love my time there. I could not agree more, though, with what Heather said about working for state AG's offices. When I was a young lawyer, everyone knew about the state SG's offices. Ted Cruz, I think, had just been the Texas Solicitor General and, was then running for Senate. This was like a really cool thing to do. There are so many other things the AG's offices do that are actually, in many ways, seem so much more interesting to me. Like the consumer protection divisions, where they're suing companies all the time for, lying to consumers and whatever. You can learn so much working in one of these offices. You'll be litigating you're doing civil cases, so you'll be learning all the skills you would need on the private side, right? Being a prosecutor is also a great experience, but it is a little different. You're doing criminal cases, which have different rules, different procedures, and whatever. The AG's offices will let you actually do the exact kinds of cases that all these boutique firms are doing now, and I just think it's great. And they're starved for talent. We have a lot of great AG's offices: Texas, Tennessee, Florida. The list goes on, and they need lots of people, because if they want to go sue the Googles of the world, Google's not gonna beat itself, and so you need to have a lot of talent to go do it. The trial right now, the Google antitrust trial here in DC, which I think there's some states involved in, has lawyers not much older. I assume you're still in school or fresh out, not much older than you, or not much more experienced than you, litigating against Google in DC federal court. That's awesome. Whether they win or lose, those lawyers are going to have that experience for the rest of their lives. So I think that's great advice.
Good morning, Charles Miller. I'm with the Institute for Free Speech. Another one of those organizations, like you were talking about earlier, just does the interest litigation. Most of the work we do is free speach, from social media to campaign finance, and we are hiring if any of you are interested in joining.
There you go.
And so that's not that's a pure question or a comment, not a question. So sorry.
Good morning. My name is John Farmer, and I'm an IP attorney in Richmond, Virginia. As you can tell, I'm entering the stage of my life where I might be able to do more law, not for money. I'm curious as to whether any of you know whether there's ever a need for IP in these areas. I have some litigation background, used to be a federal court litigator, but the past 20 years have been mainly desk practice. I wonder if in these things angles ever come up with copyright or trying to control information through copyright, or I don't know how trademark might come in, or right of publicity, and sometimes that ties in somewhat to First Amendment things and sometimes confidentiality things. Did those issues ever arise in these conservative cause cases?
We would fund anything against big tech. I don't care what the subject matter is.
Let me throw in a codicil before you answer. The codicil is, my litigation skills are rusty, so if you're just looking for a frontline litigator, people like me are not that useful. You have people with more recent skills.
I think
Do you
it'd be a
need
team.
subject matter expertise ever in these sorts of situations?
I think that would be a team situation. So you would have the great idea, we can nail Google for XYZ thing. And then we would try to pair you up with people who, can do the trial-y stuff. But I'm not kidding. Anything other than maybe, and we kind of like Twitter now, but any company other than them, for us, anything that's bad for them is good for America. And so if you have ideas, let me know.
Yeah, I don't know how it would be useful, but I'll explore that.
I would add also, there are 2 cause-related cases that I can think of that, IP, copyright type issues have come up in them, and so I think that that's definitely possible. And I think another thing that, I think the conservative movement needs to think about is, I think everyone tends to sort of think impact litigation, that means constitutional litigation, 1983, bringing or suing the federal government. But there are the law is very broad, and there are a lot of powerful tools in law. And so, perhaps the best way to, further the goals of our movement is through thinking outside the box and using some of the legal tools that we have in an unconventional way. And I can definitely see IP as one example, even as just a piece of a particular case where that could have a really powerful impact. So whatever your expertise is in this room, I think it could be used to benefit, and so I think it benefits all of us to put our heads together and think about creative ways that we can use the law to further these goals.
Amen.
Yeah.
Thank you.
All right. Wish we could keep going. Next panel is starting in just a few minutes at 9 a.m. Please join me thanking our panelists today.
Thanks, Kate.
Appreciate this so much. Thank you all for joining us, and this panel is adjourned.